Hello, my name is Michael Tesoro and I prepared this video case note on the recent High Court case, Australian Building and Construction Commissioner and Pattinson. And it's a very important case, I think, for practitioners who are involved in regulatory investigations and litigation to fully understand, because it's quite significant, some of the commentary by the judges. Bit of background about myself. I'm a competition and consumer lawyer and I've been running my own practice for 14 years, Tesoro Legal Consulting, and I help companies with competition and consumer law matters, including investigations and litigation. Prior to that, I worked at the HCA for 15 years in a variety of roles, including as Director of Enforcement, and I also ran the HCC's waterfront investigations, so I've taken legal action against a number of union organisations. And on the presentation, I'll start with a bit of introduction, then discuss the first instance decision, then the full federal court decision, and then spend quite a bit of time talking about the High Court decision because it's just such an important and interesting case, and also a big focus on Edelman's judgment. So there was a majority judgment, then a concurring judgment by Edelman, but it really raises some very significant issues going forward. Then finally, a bit of commentary. Now, some interesting background. The facts to start with is that a subcontractor was retained to install some solar panels on a particular site in Victoria, and then two employees from the subcontractor showed up at the site and were spoken to by Mr. Pattinson, who was the union delegate. And Mr. Pattinson asked these two subcontractor employees whether they were members of the union and they had a ticket. And the reference to the ticket is a reference to the CFMMEU's long-standing no ticket, no start policy, whereby individuals are not permitted to work on sites in Victoria unless they're a member of that particular union. So when they said they weren't a member of that union, Mr. Pattinson represented to the employees they weren't able to do the work until they actually joined the union. So this case is not about freedom of association. It really is about a misrepresentation which Mr. Pattinson made to these two employees, that they really couldn't work on the site because they weren't members of the union. Some other important facts are that in the period from 2000, the court found that the CFMMEU had breached the civil remedy provisions of the Fair Work Act on at least 150 separate occasions, and section 349 subsection 1 on at least 7 occasions, and that's the provision which is the subject of this litigation. So here you've got a union which is engaging in extensive breaches of the legislation, including the very provision which is before the courts. The second observation was the primary judge made a number of findings, and one was that the union was notoriously a serial offender that had historically acted in disregard of the law and appeared to treat the imposition of pecuniary penalties as little more than the cost of its preferred business model. So these are pretty scathing conclusions against the union by the primary judge. Interestingly, these were not challenged by the union on appeal, which you would expect. So maybe these particular findings didn't bother the union that much. The other important observation is the financial resources of the union. And here the court looked at the Victorian and Tasmanian, the divisional branch of the union, and noted that they had a annual revenue of $30 million and net assets of $68 million. So this is a very well-off union with a significant surplus of assets over liabilities. So it does have the capacity to pay very large penalties. Now, a few factors were simply accepted. First, it was accepted that Mr. Pattinson had made the representations in breach of 349 subsection 1 of the Fair Work Act. He had knowingly or recklessly made false representations to these two employees. The second thing, it was acknowledged or accepted that Mr. Pattinson was acting in his capacity as a delegate of the union when he made these misrepresentations. So therefore, the conduct of Mr. Pattinson was attributable to the union. So the union was also liable for Mr. Pattinson's conduct. At the first instance, the decision was, or the matter was considered by Justice Snadden of the Industrial Court, and he decided to impose the maximum penalties available under the legislation, which is $3,000 per contravention. So Mr. Pattinson was fined $6,000, and the maximum penalties for an organisation, which is $31,500, so a total fine of $63,000. And he did that because he believed that the CFMEU's long-standing history of contravening the Act and furthering its no-ticket, no-start policy, despite knowing it was illegal, meant that the maximum penalty should be imposed in order to achieve deterrence. It wouldn't achieve deterrence if a lesser penalty was imposed. The union appealed that to the full federal court, and what happened there was the court was established with a 5-judge bench, and as you can see, there's the Chief Justice and 2 further judges with a lot of experience in criminal law matters, Wigney and Bromwich, and they held that the primary judge had made a mistake. They concluded that it was inappropriate for the judge to place so much weight on the union's prior contraventions of the Act. Rather, they should look at the conduct and the nature, gravity and seriousness of the particular conduct at issue and impose a fine relative to that. So in effect, looking at the broader conduct of the union in the past and trying to determine a penalty that would deter them from engaging in the conduct going forward was the wrong way of doing it. Realistically, the judge should have been looking at the specific circumstances of the conduct, working out whether it was at the more serious end of the spectrum, and then if it was not, imposing a fine at a lower level. And I guess one thing that's important here is the decision by the full federal court to import the idea of proportionality, which is a concept that comes straight out of criminal law. So that's going to be important going forward. So the case was appealed to the High Court, and the first observation which they made is to discuss the distinction between deterrence and punishment. And the conclusion that the court reached there was that the purpose of these civil penalty provisions, and indeed civil penalty provisions in many other bits of legislation, such as the ASIC Act and the Competition and Consumer Act, the Australian Consumer Act, the purpose behind those is the promotion of the public interest in compliance with the provisions of the Act by deterring further contravention. So they're saying that the purpose of all these bits of legislation is to achieve both specific and general deterrence. And accordingly, the penalties had to be reasonably necessary to achieve that outcome. And it didn't seem appropriate to the High Court for other factors to be given more weight. And they agreed with the primary judge that it was appropriate to consider what would impact the union sufficiently to stop them from breaching the relevant legislation. They also discussed this idea of proportionality, and the conclusion reached there was the full court had fallen into a critical error by importing this criminal law concept into this particular case. It's not a question of working out whether the penalty is proportionate to the seriousness of the conduct. You can't draw these ideas in from the criminal law. And they concluded that really the courts had been misled by the view that the maximum penalty that's to be imposed under this legislation, and by extension other legislation which imposes civil penalties, is reserved for the most serious examples of offending. They're saying that that's not the right approach. Rather, the approach is to work out what is reasonably to be considered as necessary to deter future contraventions of the Act. So basically, what is going to achieve deterrence? So they also talked about the criminal law concept of proportionality a bit further and said that nothing in the text, context or purpose of this particular section, 546, and by extension again to every other civil penalty provision in other legislation, says that the penalty is to be reserved for the most serious examples of misconduct. The legislation doesn't say that, so you can't be importing this idea into the application of this provision. They're saying that the purpose of section 546 is again to deter future contraventions of the legislation by particular individuals or organisations. They refer to the genesis of this idea of the deterrent nature of civil pecuniary penalties. And I refer to French's decision in Trade Practice Commission CSR, where he says that punishment of breaches of the criminal law traditionally involved ideas of deterrence, both general and individual, and retribution and rehabilitation. And what he's sort of saying there is that really this is an economic bit of regulation, and it's not appropriate to be looking at ideas of retribution and rehabilitation. Rather, it's all about deterrence. It's about putting a price on the contravention that will be sufficiently high to deter repetition. So it's all about making sure that breaching the Act is not seen by contraveners as a cost of doing business. Now, this is, as will become clear later on, pretty much a gloss that has been put on the civil penalty provisions in at that stage, the Trade Practices Act, but now the Competition and Consumer Act, and many other civil penalty provisions. So the question is whether this is an impermissible gloss that has been introduced by the courts. Now, what the High Court was concerned was that the approach which the Federal Court had taken was likely to undermine the primacy of deterrence of the object as the object of the civil penalty regime in this Act and other acts. And they're talking about the fact that the Union had been steadfastly resistant to all previous attempts to enforce compliance with the law. They'd been fined 150 times. They were continuing to breach the law, showing no remorse. And it did indicate that the Union had the view that these penalties were an acceptable cost of doing business. So they were critical of the full court's decision, which is really undermining the ability of the legislation to achieve deterrence in cases where there was significant repeat offending. So the conclusion which the High Court reached was that the full court had erred in treating the statutory maximum as implicitly requiring contraventions to be graded on this scale, and the maximums only applying to what they believed was the worst category of contravention. And they reiterate there was nothing in the text of the legislation which supported this particular view. Having said that, this is a very common argument you see in penalty decisions, that the serious high-level penalties are reserved for the worst conduct. So it's something that you see regularly, and it's not just a problem that arose in this federal court case. Now, I think the interesting thing here is a reference to the case of Makarian v. the Queen, and it is actually a criminal case, so that's the first point to note. But as you read what's said in that case, it says that firstly, you've got to look at the maximum penalties because the legislature's set a maximum penalty, so it's obviously important for the legislature's point of view. But second, because the maximum penalties invite comparison between the worst possible case and the case before the court. So that is clearly indicating this approach to things whereby you look at the most serious conduct and you equate that with the maximum penalty. And I think you've seen many civil pecuniary penalty cases which have used Makarian as the starting point. So clearly this is law which, whilst it's been made in the context of a criminal case, has been applied in many civil cases. What the High Court tried to do was to try and emphasise those last few words, to try and draw a distinction between what should be happening and what shouldn't be happening. And they're saying that really what goes before is qualified by the final words which said, taken and balanced with all the other relevant factors, a yardstick, and they actually included the emphasis in the judgment. So they're saying that no, it's not a case of using this worst conduct and then looking at the maximum penalty. Really, once you've done that, you've still got to look at all of the other factors and balance them up. I think that might be a little bit weak, that reasoning. Now, the other issue that the High Court looked at is this idea of circumstances of the contravention as opposed to circumstances of the contravener. And what they said was that the full court was too focused on looking at the circumstances of the contravention, what had occurred, the impact it had had on the relevant workers, looking at those factors, rather than looking at the particular contraveners. And they're saying that the focus really should have been more on the circumstance of the contravener, because what you're trying to achieve here is both specific and general deterrence. So they said the full federal court made a decision by focusing on the circumstance of the contravention, and really once you looked at the contravener, particularly the union, which had so many previous breaches, then the maximum penalty was justified. So the final conclusion that the majority reached in the decision was that the theory behind Section 546, and indeed all civil penalty provisions, is to create this financial disincentive for both companies which breach the law and other companies which may be contemplating breaching the law, that the penalty will be of such a high amount that it would be economically irrational to engage in the breach. Now, that's the theory that runs behind optimal penalties and that sort of idea. But I think they're expressing a bit of skepticism about their idea. They're saying whether or not experience vindicates the theory is a matter for Parliament. Clearly, I think in this case, the penalties are very low and are very unlikely to achieve any specific deterrence. A fine of $63,000 for a union with an annual turnover of $30 million and net assets of $68 million is not going to achieve any specific deterrence, and I doubt any general deterrence. But they're saying that really, regardless of whether this works or not, the court must do what the legislation says it has to do, which is focus on deterrence. Now, they finally criticised the full court's unwarranted complication of the court's task, introducing this notion of proportionality straight out of the criminal law, which they think should not be there. And they're saying, just reinforcing the idea that no, don't bring this idea of criminal proportionality into the mix, leave it out. Although there are a number of other criminal concepts which are used regularly in civil penalty proceedings, including totality, but leave this notion of proportionality out, focus exclusively on deterrence, protecting the public interest from future contraventions of legislation. So then Edelman has issued his own concurring opinion, but it's as close to a dissent as you could possibly see. He's very negative about the majority decision, and he's actually quite encouraging of further investigation of the issues that this case raises. Firstly, he says it's hard to imagine that Parliament intended, by simply including the word appropriate, to strip the foundations of the punishment of civil penalties, which is all based on just desert, to strip that out of the law and replace it with the utilitarian notions of deterrence. So he's saying that there's a bit of a gloss being applied to the law to see the word appropriate as bringing this whole idea that deterrence is the primary goal. And he obviously doesn't agree that that's really what the legislation is seeking to do. And he says it quite clearly in the next paragraph there, paragraph 89, the primary criterion of justice in penalising should be the desert. People and corporations and unions and other entities being punished for the conduct that they're engaging in. So really ensuring that a person is not punished more than they should be, that what the law requires, the just deserts, looking at the seriousness of their conduct and so on. So he's saying that really that should be the focus of the imposition of civil pecuniary penalties, not the idea of deterrence. And then refers to the decision in Commonwealth v. Director of Fair Work Building Industry Inspectorate, which is well known as the agreed penalties case, and he is quite critical of that decision by the High Court, which he was obviously not a member of at the time. But he describes the decision by the court in that case, rejecting notions of retribution and desert together rehabilitation, as radical. He says the effect was that deterrence became the sole reason why civil penalties had to be imposed at particular levels, and desert has just been pushed out entirely. And I think it's fair to say he doesn't believe that that was justified. And this is something that I think he's sort of saying that, you know, the High Court has effectively abolished the idea of just desert as a relevant concept in relation to civil pecuniary penalties. It's almost like they've abolished this through a court decision as opposed to a legislative outcome. And he also says that in paragraph 103 that unless and until there is a direct challenge to the idea that deterrence rather than desert is a principal object of civil penalties, or Parliament decides to clarify the whole issue by saying that, proportionality is relevant and just deserts is what it's all about, then these problems are going to keep arising. And it seems to me he's almost inviting a challenge to this principle in a future court case, because if it's challenged full on, head on, that there's a view that potentially the idea of deterrence will be seen to be lacking in any real foundation. And there's a very long quote at 107, but I think this really gets to the heart of it. He talks a lot about the abstract utilitarian theory that effectively you try and set a penalty at a level that will achieve deterrence, and that companies, individuals will weigh up and engage in a rational process and decide it's not appropriate to engage in a breach of the law because the costs outweigh the benefits. But what he's saying there's some very big assumptions about whether this theory will work. And his conclusion is that often when this issue is considered by the courts, the information before the court is woefully inadequate to actually identify the tipping point at which a company or an individual will say, I'm not breaching the law, it's too much of a penalty. And then his final sentence is, I think, just a classic. In the real world, a regression analysis which attempted to identify that tipping point or that point would be the legal equivalent of searching in a haystack for a needle that probably does not exist. So he's saying you could spend an enormous amount of effort to try and work out what the optimal deterrent tipping point would be, and the chances are you wouldn't be able to work it out. The needle is not in the haystack at all. Then there was an issue that I think Edelman pointed out that was relevant, and it was effectively that the law, as stated by the High Court, is clearly the current standing of the law, and the courts have no option but to apply that law. But he does believe that the approach which has been taken and has been established through various court cases is incorrect. I think there's no doubt that he's saying that the idea of making deterrence the primary criterion on which civil penalties are determined and excluding just deserts ideas and proportionality is not correct, but the court has to follow the law. Another issue that he raised, which I think was very relevant, was that the full court made a couple of findings. One was the penalties should be reduced, but the other finding that they made was that the primary judge had not given the union or the individual any credit for having cooperated with the case and the investigation and stuff. So effectively what he's saying here is that because the full court found an error in the primary judgment, this court, the High Court, cannot simply determine the matter. They really have to remit it back to the court to have this issue looked at. So there he says that this court cannot mechanically affirm a decision of the primary judge that has been held to be wrong. It needs to be remitted back to the judge to consider the discount which should have been provided to the individual and the union for having cooperated. That's not what the majority decided. The majority did not decide to remit it. They decided to resolve it finally and allow the appeal. Now, just some commentary here. I think the first obvious observation is there's some discord on the High Court about the deterrence rationale, not just on the Fair Work Act, but under civil penalty provisions generally. There's a strong view by Edelman that really deterrence has been given this preeminent position in the law, which is a bit of a sidewind. It's a bit of a gloss on legislation. The legislation doesn't talk about deterrence, certainly doesn't talk about proportionality or just deserts. So a decision has been made by the courts to make deterrence the number one consideration, in actual fact the only consideration when setting a civil penalty, and I think there's a strong argument that's not correct. Now, Is it likely that the High Court, when they face with this issue in the future, is going to overrule this whole idea? I'm not too sure, but it is something that maybe the Parliament needs to clarify, particularly the view that the deterrence concept is a theoretical concept which really is impossible to work out if it's going to work. There just seem to be so many examples of penalties which are not achieving optimal deterrence, particularly in these areas like Fair Work, where they're very low penalties. You'd think that in some of these other areas, particularly the Competition and Consumer Act, the Australian Consumer Law, which have massive penalties of $10 million, 10% of turnover, 3 times the value, that they're achieving some level of deterrence. Or in the criminal cartel area, obviously, you'd expect imprisoning people would achieve some deterrence. But when there are these lower penalties, there's a real strong argument they're not achieving any deterrence, and whether just deserts should be something that's introduced to more adequately reflect a fair penalty. The clear thing is the penalties are much too low. They're not going to have any impact on a union with the financial resources of the CFMEU, and they've really got to be increased if they're going to have any deterrent effect whatsoever. And it's very unlikely now that we have a Labor government in power, they're unlikely to change the penalties here. The final observation I just feel is relevant is the CFMEU has been behaving very poorly, breaching the law with impunity, and I guess it's been doing it under a coalition government, but it really can't continue to do that, because if it does that in the current environment, all its bad conduct is going to be sheeted home to the Albanese government, and they're going to be put on a lot of pressure to control this union, who is simply breaking the law without any regard. So I think it's sort of an important time for the union to realise that it needs to pull its head in and stop breaching the law so blatantly, because it's just going to damage the Albanese government, which is going to need all this help it can get, given the changing economic circumstances it's going to have to be dealing with in the future. So a call out to the union that it's time to start behaving more responsibly when it comes to breaches of the Fair Work Act. So that's all I had. Hopefully that's been interesting. It's a really important case and well worth reading, particularly the dissent, or not really the dissent, but the pseudo dissent by Edelman, which is really the great deal of thought that went into that judgment. So if you have any questions about this particular presentation, feel free to give me a call or drop me an email. Bye-bye.